We have everyone here. Counsel for the appellant, I have two questions. First, did you wish to reserve any time for rebuttal?
Yes, Your Honor. I'd like to reserve 5 minutes.
Thank you. And the second one is something that I'm often asked. Can you give me how you prefer your surname to be pronounced?
Yes, it's Alagna.
Alagna, thank you. And with that, I guess we are ready to go.
Thank you, Your Honor. May it please the court, Melissa Alagna of Florida Appeals on behalf of the appellants, NM Residential and 949 Cleveland Street. We're asking this court to reverse the trial court's order dismissing the appellant's complaint with prejudice. The trial court erred in granting the motion to dismiss the complaint for fraud because it failed to apply the controlling authority out of the Florida Supreme Court, which is found in the Oceanic Villas case. And also, it misinterpreted the holding of the Billington case out of the 5th District, which it relied on in issuing its order. Additionally, there was a second ground for dismissal included in the motion to dismiss, which the trial court did not reach because it reached its decision solely on the issue of the release. But the second issue of caveat emptor could also not have been a basis for dismissal because there is an exception that is applicable to the facts of this case to that doctrine, namely because we believe that under these facts, the seller has undertaken to disclose certain facts and failed to disclose the whole truth when it did so. And additionally, the allegations of fraud were sufficiently pled in the complaint to overcome a motion to dismiss. The primary issue, and the one upon which the trial court based its decision, is whether the non-reliance language that's included in the purchase agreement is sufficient to act as a release of the appellant's fraud claims against the appellee. The appellants were purchasers of a commercial property, which was owned by the appellee, and the purchase and sale agreement contains as-is language, non-reliance language, and a release for claims arising out of the condition of the property. After closing, the appellants discovered that there were 3 separate statements made by 3 of the seller's representatives, which were false, and the appellants sued the appellee for fraud. The trial court subsequently dismissed the complaint with prejudice, finding that the release contained in the agreement precluded those fraud claims. And there are 2 cases which are binding on the resolution of this release issue. The first of which is the 1941 Florida Supreme Court case of Oceanic Villas versus Godson. And in that case, the Florida Supreme Court distinguishes between a stipulation in a contract, which would recognize that fraud may have been committed, and then stipulates that if the fraud is found to have been committed, that the contract should not be contestable on account of that fraud. And it distinguishes that type of language from a contract in which parties merely stipulate that no fraud has been committed, and that neither party relied upon the representations of the other party.
Mrs. Alagna,
yes.
Mrs. Alagna, let me stop you there because there were a lot of cases, and so we're all trying to synthesize all of them. So I came up with 3 basic understandings, and I want to run them by you to see if they're consistent with what you're saying. If you have a non-reliance clause alone in your contract, then dismissal would not be appropriate, but it might be evidence that would warrant summary judgment. So if you have a waiver or a release clause alone, it doesn't necessarily constitute a waiver or release of a fraud claim. But if you have a waiver and release clause plus a non-reliance clause, then dismissal would be appropriate. That's how I've sort of synthesized all that case law. Is that consistent with what your argument is, or no?
That is consistent, Your Honor. And the only thing I would add is that if you have a waiver and release clause, which is specific to the representations, then it would be sufficient to preclude the fraud claims.
So your position is just a general waiver or release clause would not be sufficient, even if there were also the reliance clause in the contract when you're reading the whole thing together. The waiver or release clause has to specifically state that it would be releasing any fraud claims also.
Well, I don't think it needs to specifically state that it's releasing fraud claims. For example, in Billington, the language that the 5th District upheld says that the buyer is not relying on the seller's statements and waives any rights or claims arising from any such statements, promises, or representations. So it does not use the word fraud, but it is sufficient.
it specifically relies on, it specifically sort of incorporates that reliance language. It makes it clear that those two things are supposed to be read together.
Correct. That the
And then
release is
You
specific.
have, go ahead.
And your position is this contract, even though it does include the reliance clause and a release clause, you shouldn't be reading those together?
No, you should not be reading these together. So this contract has a non-reliance clause, which states that the purchaser, the appellants, are not relying on the representations made by the appellee. And then in a subsequent paragraph, it includes a release that is talking about releasing claims arising out of the physical, environmental, economic, or legal condition of the property. That's very different from the language that was approved in Billington, which talks about releasing claims arising out of the representations.
So it says, we have the purchaser is not relying upon any representations, warranties concerning the property or its value. And right there, it should say, what should it say? What should follow that, according to the case law?
Well, if we're going off of the example we have in Billington, then right after we're talking about not relying on these representation, it would include language such as, and waives any claims arising out of these statements or representations.
So so going back to that distinction that in Oceanic and Billington, I guess, is so what the distinction that I drew from is that there's a distinction between saying you didn't make any representations, or maybe going a step further and saying I didn't rely on any representations, and then the next step of saying if there were representations, I'm releasing any claims I have based thereon. And so we have the former, which is saying I'm not relying on anything you said that might have been false, and that's not good enough. Is that right?
That's not good enough under Oceanic Villas or Billington. As a matter of fact,
what about this? What about seller disclaims the making of any representations? Is that just saying I didn't lie to you, or is that saying when he says disclaims the making of? What does disclaims mean? Does that mean, you know what? I'm telling you I might have lied to you, but what does disclaiming mean?
well,
That's in the first 9(2). Yeah.
The supplemental authority that we filed last week, which is the McIntosh Fish Camp case out of the 5th District as well, just like Billington, contains contract language, doesn't use the word disclaims, but it says seller makes no warranties. And I would offer that is close to saying that seller disclaims any warranties. And the court, the 5th District, found that language was not sufficient to act as a release of the fraud claims and reverse summary judgment.
So that's just saying I didn't lie to you.
That's
I just
just
claim
saying-
making it. Okay.
The next binding case, the second one, comes out of this court, and that's Marjan versus Lane. And in that case, this court applied the Oceanic Villas holding and held that a contractual provision, which states that the parties recognize no fraud has occurred, would not bar subsequent claims for fraud, which is consistent with both Oceanic Villas and Billington.
Let me ask you just sort of, and I don't know if this ventures too far into caveat emptor territory, but do we need to take into consideration that was a dissolution case and not an arm's length commercial transaction that we have here? Does that factor into our analysis of that case at all?
I don't think it does, because both Billington and Oceanic Villas were commercial cases, and they contain the same rationale and the same language as to what is required for the waiver of the fraud claims.
Okay.
Ask you this. So if we were to conclude that it was improper to dismiss based on a release that didn't actually release fraudulent misrepresentation, and we were to consider as a tipsy coaching argument, which you were, heading off at the pass, so to speak, in another issue. So could we, let me ask you this about that possible tipsy coachman argument. You talk a lot about the fact that you sent somebody out, or you investigated, and this distinguishes the other caveat emptor cases in which, you just blithely went along. You didn't look into it yourself. But if you sent somebody out, if the purchaser sent somebody out, isn't it just as bad for them factually to not verify that the things that they identified were fixed? In other words, oh, fine, you sent somebody out and you actually identified things, but then they told you they were fixed and you didn't send somebody out to verify that. You just took their word for it. Isn't that just give rise to a caveat emptor defense yet again? That's good.
No, I don't think so, because what caveat emptor protects is the seller's ability to not disclose information. Even of known defects, they're not required to disclose the information. Now, the exception that I raised earlier is that if they're going to undertake that responsibility and they decide to disclose facts, then they're required to disclose the whole truth. And in this case, we're saying it went a step beyond that. Not only did they not disclose the whole truth, but they in fact lied about the steps that had been taken in response to the punch list that was submitted and the issues that were going to be repaired.
I can see real quick. So if I'm understanding, I can see if you clocked over, there was a superficial fix that actually prevented the detection of the lie that you're alleging, which is that like the windows were fixed. But if you're just relying on the averment that, hey, we fixed it, can't caveat emptor still be a defense to a fraudulent misrepresentation if you didn't do anything to verify that it was actually fixed? In other words, leaving aside active concealment, you have, hey, I got my guide here, there's a punch list, and can you look into that? And then they said, yo, all done, and you didn't come back out. Doesn't that mean can caveat emptor still be a defense to the fraudulent misrepresentation that we fixed it if you didn't come back out and verify that, because you weren't prevented from coming back out?
No, I don't think caveat emptor protects them in that instance. I think it would protect them if they had chosen not to disclose whether the things were completed or not. But once they decided on 3 separate occasions to say, yes, these things were addressed, then that fits squarely within the exception that if they're going to make these disclosures, then they need to disclose the whole truth of what occurred.
I have a question. I'm sorry. I have a question regarding the contract and the representations about and the issue of fraud. I've looked at the contract and you have seller representations in 7A. You have a statement in paragraph 16 that the parties agree that there are no oral agreements, understandings, representations, etc., that are not expressly set forth herein. And you have a number of releases, second, third, whatever. How do you get around all those? That's my concern. It seems like the contract says the only representations are in paragraph 7, and paragraph 16 says, hey, no one is relying on anything other than what's in here. In paragraph 16, the parties agree there are no oral representations other than these. And then you have the releases. I'm wondering if that creates any barrier to your cause of action. And if not, tell me, why not?
Well, I think in all of that language and in the amendments that are subsequent to that language, it's all devoid of any specific release relating to the representations, which is what Oceanic Villas required and what the Billington case required. And in those contracts, there was non-reliance language. There were merger and integration clauses saying that there were no agreements other than what was included in the written document. And it still wasn't sufficient if it did not have the specific release relating to the representations. So the
Wait a minute, can I pause for a second there? I didn't quite clearly ascertain from your brief whether you were suggesting that the release had to be specific to the actual representation, which doesn't make sense because the representation wouldn't have been necessarily made at the time you entered into the contract. Now, are you saying that you're not saying that it has to say, hey, you remember when you said the windows were fixed? We're not going to sue you even if that was fraudulent. It doesn't have to say that, right? It just has to say if you made fraudulent representations, we're releasing any claims that could be based on those.
Correct. So the release would have to say that it is waiving claims arising out of representations, but it wouldn't specifically list what those representations are, the windows, the gates, those kinds of things. But it would be specific to a release of representations made by the seller.
What cases, going back to the caveat emptor thing, let's say that we decide that you're correct, that the release didn't release these fraudulent representations and claims. Going back to the caveat emptor thing. So let's say what cases support that? I mean, I know you're relying, I know the cases you cited said, well, these folks didn't even come out. They didn't even do any due diligence on their own. So buyer beware. You just trusted, implicitly your negotiating partner. But what cases would undermine my hypothetical counter to that, which is, hey, well, that's what you did when you just trusted that they fixed the things that you went out and looked at the first time, but failed to go out and inspect after they said they fixed them.
So the TransCapital Bank case out of the 4th District sets forth the exceptions to the caveat emptor doctrine. And it includes the exception that I've talked about, where once a party undertakes to disclose facts and fails to disclose the entire truth regarding those facts, caveat emptor would not apply.
So in other words, you brought up the topic, and then now you're lying to us about the topic.
Filed by both sides.
Go ahead.
Correct. And both supplemental authority filed by each side reiterate those same exceptions and include the exception for lying about facts that you chose to disclose.
So in other words, we characterize the law. Let me see yours was the Florida holding case. That was your case, or is it? Yeah.
Ours is McIntosh Fish Camp.
Oh, okay. Sorry, I got the wrong one. Okay. Well, anyway, you're saying both include the standard that supports your position, though, and that is, in other words, if you once the topic is broached, then buyer beware goes away, and you better speak about it truthfully, or else you're going to be liable for a fraudulent misrepresentation claim. Even if you trust but don't verify, to quote Ronald Reagan.
Correct. So the general rule under caveat emptor is they have no duty to disclose, and that protects them from having to make any sort of disclosures. The exception says if they choose to go about and make those disclosures, then they can't lie. They have to disclose the whole truth about the facts that they're endeavoring to disclose. And in this case, the complaint states that—
I did tell you we are past the 15 mark here. So I think we better move on, since we are 2 minutes past, and move on to the appellee's point of view. And I will unfortunately have to confess 2 cases in a row now. I have missed the clock. Mea culpa, mea maxima culpa. You kind of guess where I went to elementary school. With that in mind, we will allow the appellee to have 2 extra minutes as well. And I apologize to you both. I was listening to the argument. I was trying to read an opinion by Judge Posner that I found out of the 7th that talked about non-reliance clauses and the such. And I apologize that I missed you. So with that, we will turn to Attorney Wood.
Yes, and may it please the court. My name is Rachel Wood, and I represent the appellee, Prospect Park Development, LLC. I'll get into Ms. Alagna, and I apologize if I mispronounced that, points in a second. But really, I think what's striking about this case is in the restatement second of torts, there's it's section 541. There's the quote that if one induces another to buy a horse by representing to it to be sound, the purchaser cannot recover even though the horse has but one eye, if the horse is shown to the purchaser before he buys it and the slightest inspection would have disclosed the defect. And that's really, I think, what the essence of this comes down to when you look at the caveat emptor side of things. And of course, the PSA, the purchase sale agreement, we can talk about the clauses in depth, there, which we will. But I think in terms of the caveat emptor, that's really what we come down to. And what appellants are skipping over is that the PSA was entered into on April 11th, 2018. The issues with the balcony and the gate are known around that time because they allege that a question was asked about it. After the PSA is signed, then there is a response. The due diligence period begins, lasts 30 days. The Winter Park Construction provides the punch list on April 19th, outlines all of these issues. Pursuant to Section 5 of the PSA, the appellants had the opportunity to provide a disapproval notice. They didn't. In fact, it says that except as otherwise set forth herein, in the event purchaser fails to deliver the disapproval notice on or before the expiration of the due diligence period, purchaser shall deem to have accepted the condition of the property in its as is, where is, and with all faults conditions. They had a 3-page punch list. They did not provide a disapproval notice, and pursuant to the terms of the PSA, they accepted the property, accepted the condition of the property in its as is, where is, and with all faults condition.
How is that different? Is that different than the other cases in which there's as is clauses and the absence of a release of actual fraudulent misrepresentation undermine the defense?
So I don't believe so. What I do think is that we're looking at multiple steps here. I think the first issue is that this is an active agreement that they have under the PSA that by not taking action with the disapproval notice, which occurred well prior to the alleged comments in June and July, that they have accepted the property in its as is, whereas, and with all faults condition.
Ms. Woodland, I know you're in the middle of answering Judge Atkinson's question, but one thing that I do want to comment on is in paragraph, was it 9.2? Why can't I get, unfortunately, sorry, my page is frozen there. So let me see, 9 sub 2.
Mm-hmm.
It says, purchaser agrees that the property is to be sold to and accepted by purchaser in its as is condition and with all faults on the closing date.
Yes.
Couldn't that be read to permit purchaser to say, here's all the stuff that, here's all the stuff we found wrong. And you say, okay, we'll fix that. But under the contract, they're only obligated. It's sort of by saying, we agree to accept it as is and with all faults on the closing date. Isn't there room in there for an assumption that if we say, here are all the problems and you're going to fix them, then we'll get the, I'm not articulating this very well. And
I understand what you're trying to say, and I don't believe so, because one, I think that's what the due diligence period clause
they seem
allows.
Consistent.
Yeah, I think they're consistent. And I think that also that, the due diligence clause is consistent, that look, we understand you have a right to do due diligence, and it's a very expansive due diligence clause. And if there's problems when you do your due diligence, you can do a disapproval notice. If you don't do that, then you agree that you're accepting it with all the faults as is, and specifically.
But that's with all faults as is, as of the date, as of the disapproval date, the closing of the due diligence period.
Correct, which they knew about all of these things through the Winter Park Construction punch list, and they knew about them prior.
Right, and that's I think that's what I'm trying to. You know what? I have gotten you off track from Judge Atkinson's question.
Well, I'm interested in that, Judge Yoakum. Are you saying that, in other words, and perhaps I'm just thinking of something new, maybe not. If they're allowed to rely on the issues being resolved by the time of the closing, why should it matter whether they didn't have someone come out prior to that time again to verify their trust in your representation? Oh, we fixed these things.
Well, I think, okay, so I think maybe let me try to answer the question, and if I'm not getting it quite what you're looking for, let me know. So the first issue is that there are no statements made prior to the closing of the PSA that they have alleged are fraudulent. So to the extent, and that distinguishes the cases that they're also relying upon, is there's no allegation that this PSA has been obtained by some sort of fraud.
I said,
Okay.
can you slow down? So there's no statements prior to the, say that again.
There are no statements prior to the PSA being entered into that appellants allege were fraudulent. Okay. So this is not an agreement. There's, I think there's a difference when you have fraud in the inducement for the entire contract. And what they're saying is that they were somehow fraudulently induced by these three statements in June and July to close upon the property. And I think that's an important distinction, because we aren't looking at a case in McIntosh, similar to the McIntosh Fish Camp, where, the person was dissuaded from seeking counsel, from where there were obviously, there were strong facts that the individuals had, concealed issues prior to the contract being entered into.
Okay, so there's no, so that we can't argue that the assurance that the punch list had been fixed induced them to enter into the PSA, but they can still argue that it induced them to go to closing, since to repeat what Judge Yoakum identified in the contract, it said, everything's gonna be fine at closing. So can't there be a fraudulent misrepresentation claim based on their inducement to go to closing and give you money for the property?
I don't believe so, because one, they did not take. One, there were, there was the due diligence period. They didn't raise any concerns with the due diligence period or any concerns in 7 and 8, paragraph 7 and 8 of the PSA. They agreed to specific representations and warranties. Then in the First Amendment, Second Amendment, Third Amendment, and Fourth Amendment, they accept those representation and warranties and affirm the terms of the agreement. If they had concerns about wanting to make repairs of the Winter Park punch list as part of the agreement, that could have been negotiated and entered into at any time in those amendments. They don't allege that they attempted to do that. They don't allege that that was a concern. And they've had a chance.
Why would they need to if you said everything was fine?
Well, I take issue that, like, I think it, they allege that the issues on the punch list had been addressed. Okay. And then the specific issues that they allege are, just very quickly, that there was the comment about the windows. And then there was also the comment that the balconies and gate systems were done. Particularly with regards to the comment about the windows, the PSA, which they had entered into months prior, says that they are not going to rely on any representations or warranties that are outside of the PSA. And that they assume that they are entering into the PSA based upon their own investigation, and that they aren't relying upon any statements by Prospect Park.
By the way, I'm getting confused. Are we still talking about Cave and Emptor here?
I think we've mixed it all up. I think we've mixed it all up.
Those are the same facts as those other cases where those contracts said that, and you still could not get dismissal of your fraudulent misrepresentation claim.
Yes.
So I'm sorry, I apologize. And maybe I don't know if anyone shares my confusion. Are we talking about Cave and Emptor? Or are we talking about the dismissal based on release?
So sorry, I thought we had kind of moved on to the dismissal based,
okay, go
based
ahead.
on your question.
And that's fine. Go ahead. Then my question is, well, that's what all those other contracts said. And when those other courts said, nope, that's not good enough, you didn't release for this fraudulent misrepresentation claim.
I disagree with that statement. I think Billington addresses that. when, Billington looks at Oceanic Villas, and to go back to Judge Rothstein-Yoakum's point that, the way she digests the information is that a waiver plus a non-reliance clause plus a release clause would be sufficient to uphold a motion to dismiss. And I do think we have that in this case. And I think Billington really addresses this. Not only
The
that.
distinction, sorry, is the distinction between the distinction in Oceanic still relevant? I think it was repeated in Billington, wasn't it? Which is there's a distinction between saying, I'm not relying on any lies you told me or anything you represented to me. And the seller saying, I didn't lie to you. And what is sufficient for release, which is a fraudulent misdemeanor, which is even if you lied to me, or like I might have lied to you, or to say it from the buyer's perspective, even if you lied to me, I'm just going to release any claim I have based on that misrepresentation. Is that still viable, that distinction? And where in this contract does it do the latter?
So I may be misunderstanding your question a bit, but
That's understandable.
Let me point to the contract language that I think addresses your concern, and if not, we can explore it more. But in 9.2, it specifically says that purchaser is not relying upon any representations and warranties other than those specifically set forth in paragraph 7A above, made by seller or anyone acting or claiming to act on seller's behalf concerning the property or the value. And then in 9.3, they release claims arising out of the physical, environmental, economic, or legal condition of the property.
That's it. Okay. All right, go ahead.
Okay. And then they affirm those representations and warranties and the release. And then in the Third Amendment and the Fourth Amendment, they again release claims regarding the purchase agreement or which are otherwise related to purchaser's acquisition of the property. I think that given the very specific representations and warranties, the merger clause, the waiver clause, and the non-reliance provisions in this agreement, that addresses Billington's concern and the way they integrate, the way they take Oceanic Villas in reaching that decision. I think their conclusion that on balance, the sanctity of a contract and the predictability of an outcome in a dispute should take precedence, whereas here the parties clearly manifest the intent to void such claims.
By the way, I was following you, but I just want to make sure for the benefit of all who had to suffer through my question, the distinction is between, to quote Billington, a contract affirmation that no fraud has been committed, which does not negate a fraud claim, and a contract that stipulates that even if a fraud may have been committed, such a claim may not be asserted. And I'm not sure that what all the things you just quoted me falls into that shunts this into the latter category. That even if a fraud may have been committed, I'm releasing any claims I have as to that fraudulent misrepresentation.
So the question is, do you win on summary judgment or do you win at the motion to dismiss stage? I think is really how it plays out. So where here, what in this contract here shows that you're supposed to win at the motion to dismiss stage, as opposed to theoretically at the summary judgment stage? I'm not trying to make any pronouncement with respect to that.
I understand. I think that on the whole, you have to look at the whole contract. And I think that when you look at the whole contract, for example, paragraph 26 says, this agreement constitutes the entire agreement between the parties, their real estate agents, there being no oral contracts, representations, conditions, or warranty expressed or applied in addition to this agreement. You look at the integration in paragraph 16. And then you also
the integration. I mean, that like a merger clause, or is there a distinction between?
It's a merger clause.
Specifically, in the case law, it says that doesn't get you out of a fraudulent misrepresentation claim.
No, I mean, I think you have to look at it. These are two sophisticated parties.
Yes.
I mean, this is a $47 million deal for multiple buildings. This is not your, your case where you have, two family law, plaintiff and defendant, or, you have an unsophisticated party. These people were represented by counsel throughout the entire thing.
Since you said they were sophisticated. So okay. So since you're talking about this in pari materia whole document analysis, what about in 9D where it says purchaser agrees that the properties? Sorry, I was the wrong spot. I scrolled too far. I think it's 9D. What it says that they're talking about the cap and the floor. And so and that they don't apply to or limit seller's liability for fraud or an intentional misrepresentation by the seller. Is that evidence that fraud and intentional misrepresentation claims were not waived? It's on page 280 of the.
Well, I don't believe so, because that's relating to warranties provided to seller by any general contractor. And specifically, that clause relates to their ability to sue the actual builder of the property, which they have done. That's just taking the 3 and then making sure that the carve out is there, that they can still sue the contractor, which they have done.
Each party agrees. Okay, I'll take a look back at that. Go ahead.
All right. So, I think also, while the court did not consider the Florida Holdings case, I do think that is instructive to some extent. While it doesn't deal with Oceanic, I think it shows that when you're dealing with complex businesses that are, in a multi-million-dollar type of deal, the PSA is the controlling document. It's a similar situation. The buyer discovered issues with the property's physical condition, including roof leaks, HVAC failures, and mold growth. Buyer then sued the seller for damages, alleging breach of implied covenant of good faith and fair dealing, fraud and inducement, negligent misrepresentation, negligence, and unjust enrichment. This was actually a summary judgment case, but I think that the trial court's reliance, on the PSA express terms and the claims were adequately covered or expressly contradicted by the PSA and were thus not actionable should govern the determination that there is not a claim that appellants can bring that would be viable. Because I do believe that the non-reliance provisions, specifically since there were negotiated for representations and warranties, and the fact that there were multiple releases relating to the property, the physical condition of the property, are sufficient to say that you are releasing any claims about these balconies and this gate that you knew of, but didn't, disclaim or, didn't do anything with after the due diligence period.
Okay, can I go back to your construction on page 280, the record of subsection D of section 9 of the agreement? It says, notwithstanding the foregoing, however, the liability cap shall not apply to or limit seller's liability for fraud or an intentional misrepresentation by the seller. I'm not really sure. You said that has to do with, I guess, indemnifying against claims by, the right to take an action against the builder.
Shall be assigned to purchaser upon the closing. So, I mean, I still don't think that applies to this situation because, I think that's saying that any warranties that were provided by the general contractor to the seller are assigned to the purchaser upon closing. They aren't alleging that the contractor made specific representations to us. And that then we pass, I don't think that applies.
Okay.
Because Winter Park came in, they provided their punch list. There's no allegation in the amended complaint or the original complaint that, they requested additional destructive testing or any sort of follow-up after Winter Park provided that punch list. In fact, they alleged that it wasn't until after closing that they performed the destructive testing that would have been allowed under the due diligence period.
You're getting close. You have a minute left.
Yes. So just really quickly, I do, I don't think that the appellants can state any sort of cause of action that both gets over the hurdle of caveat emptor, because none of the exceptions apply, and as stated in my brief, and then also that Billington and this Florida Holding 4800 case, I think, is instructive when you have two highly sophisticated parties who have entered into a very detailed PSA agreement, and that dismissal with prejudice at this stage was appropriate.
Thank you. We are ready for rebuttal. You have your 5 remaining.
Thank you, Your Honor. I wanted to address the Florida Holding case that counsel just mentioned, because I do also believe that it is instructive. And that case is factually distinguishable on 2 points. First, that case found that the purchase and sale agreement language controlled because the purchaser had not alleged sufficient facts to show an exception to caveat emptor in their complaint. And so they were left with just the language of the purchase and sale agreement and no exception under caveat emptor. Now, if we look at the language of that purchase and sale agreement, in addition to saying that the buyer has not relied and will not rely on, and seller is not liable for or bound by any express or implied warranties, guarantees, statements, representations, or information pertaining to the property. This is akin to the language that we see in Billington, where there's a specific release. The seller is not liable for these representations. And this is a language that we've pointed out is not included in our purchase and sale agreement or any of the amendments thereto. There's only a release in our case for the condition of the property. Additionally, Billington points out that the court is upholding the dismissal based on the release because the disclaimer clauses in the contracts contradicted appellant's assertion of actual reliance and effectively waived the claim. All of the provisions that counsel pointed out in the purchase agreement that we have here deal with non-reliance issues, but they don't go as far as releasing the claims based on any of those sorts of representations. And so it doesn't go as far, the contract here doesn't go as far as the contract did in Florida Holdings or in Billington.
Can I interrupt you for a second? I can't find it right now. I can't recall if there was an amended complaint, but in reading the complaint, the complaint seemed to focus on the condition of the property, and the representations concerning the repairs were relegated to like a parenthetical. And that was it. And it seemed to me that the claim was primarily based on the actual condition of the property and claims that you weren't and basically that was the focus, and that you weren't so much relying on the after made comments about we're going to fix it. Is that not a fair characterization of the complaint?
No, so there is an amended complaint that begins at page 250 of the record, and it includes detailed recitation of the facts regarding the representations on 3 separate occasions by 3 separate representatives of the seller, and then states that not only were those representations false, but also that these representatives knew that they were false at the time that they were made. And those specific allegations are at page 253 and 254 of the record. I know counsel spent a little bit of time on the as-is language that's included in the contract and the merger clause and the non-reliance clauses, but the fact of the matter is that The cases, as your honors pointed out, including Oceanic Villas and Billington even, say that non-reliance clauses, as-is clauses, are just insufficient to overcome fraud claims without a specific release related to those representations. And I think effectively what the Florida Supreme Court is telling us is that if we are going to allow a seller to avoid the consequences associated with lying to a purchaser or defrauding a purchaser, then the language of the contract must be clear that that was a party's intention to do so, to release those claims. And we don't have that kind of specific language here. I also wanted to point out that the McIntosh Fish Camp case, which we cited a supplemental authority and counsel mentioned in her argument, also had representations or dealt with representations that were made during the due diligence period. And the court still reversed the summary judgment on the fraud claims and didn't engage in a discussion or really distinguish the representations simply because they were made during the due diligence period and after the contract was signed. Another thing that
Let
we
me
have.
let you know you're within 10 seconds.
Okay, thank you, Your Honor. And we respectfully submit that the order dismissing the complaint should be reversed because there is no express language releasing the fraud claims, and there's an exception to the doctrine of caveat emptor, which applies here and would prohibit dismissal on that as well.
Thank you. And thank you both for the presentation and your willingness to go beyond the time originally allocated. I was glad to see there was no objections. I will catch it from my panel members, I'm sure, later, but at least I can say the lawyers were on my side. I thank you all, and please have a nice day and stay well. For those of you who are listening, we're going to take about, it's 12:33. We'll come back at 12:44. We're going to take about